Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm very pleased to be moderating today's program. For those of you who want even more information, either about the topic that we're going to be talking about today or anything else in the world of consumer financial services, please don't forget about our blog, consumerfinancemonitor.com. We've hosted our blog since 2011 when the CFPB became operational. There's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you access your podcasts. And also, please let us know if you have ideas for any other topic that we should consider covering on a future podcast show or speakers that we should consider as guests on our show. And now I'm delighted to hand the program over to Mike Kilgarriff.
I'm Mike Kilgarriff, a partner at Ballard Spahr in the Denver office and one of the leads of our State Attorneys General Consumer Finance Response Team. I'm thrilled to be hosting this session today. As many of you know, we're seeing a notable increase in regulatory activity from state attorneys general, particularly in the financial services sector, whether it's data privacy, consumer lending, servicing, or marketing practices. AGs are asserting their authority more forcefully and across a wider range of issues than ever before. Today's discussion is designed to be practical. We're going to walk through a real-world playbook, what to expect when you receive that first inquiry, how to respond effectively, how to manage risk and reputational exposure, and just as importantly, how to proactively prepare before the state attorney general knocks on your door. We'll also talk about multi-state coordination, the evolving regulatory landscape, and how federal-state dynamics are shifting in the wake of changes at the CFPB and other federal agencies. Obviously, we have a lot to cover. I'm looking forward to a thoughtful, candid discussion. Before we dive in, let me introduce my Ballard colleagues joining me here today. In addition to myself, we have Hank Hockeimer, head of our white-collar practice out of Philadelphia, Adrian King, one of the co-leads of the State AG initiative here at Ballard, also out of Philadelphia, Jenny Perkins, a member of the State AG financial response team, also in Philadelphia, and then Denver's Joseph Schuster, joining us today from the Consumer Financial Group, and notably the only non-litigator, which will bring a really interesting perspective on proactive compliance for state AG initiatives. Before we really dive in, let me just walk through the agenda, because obviously we have a jam-packed agenda here and a lot to discuss. I'll cover a little bit more welcome and an introduction and set the table. And then Adrian and I will talk about the enforcement landscape. Probably, Hank will join in of where the state AGs are focused in consumer protection. And then we'll get into these practical implications of state AG CIDs, subpoenas, such as the common triggers and targets for financial services companies. We'll focus on preventative measures, compliance with state laws, changes that are happening in real time, and then responding to investigations, some of the practical steps that companies can take when they're facing a state AG inquiry. Oftentimes, we're seeing these state AG inquiries have parallel federal investigations. And we'll talk about what it's like to coordinate some of the best practices of coordinating with federal agencies. We'll talk about strategic considerations and settlement dynamics. And finally, we'll touch on long-term prevention. building an AG-ready compliance program. So briefly, why are we having this presentation? I mean, in many respects, state AGs have been proactive in the consumer finance space and the consumer protection space for a long time. But what we're seeing is an unprecedented reduction in federal enforcement. For anybody who's watching the news, I mean, I think it came out this morning that the CFPB's position is that they only need 200 employees to run the entire agency. There has been a gross reduction and change in strategy from the SEC, the FTC. So it's not just the CFPB. And this is having widespread implications in the consumer finance space. You're seeing state AGs pick up that mantle. I mean, this was a big prediction of ours. If you follow Ballard's webinars, we did a 3-part series. Maybe it became a 4 or 5-part series, but this is an ongoing shift. You're even seeing the states talk about filling that regulatory void. The Oregon Department of Justice filed suit against Coinbase and directly cited the lack of SEC action. And so we're seeing a real shift, something that didn't happen in the first Trump administration. And this is why it's so important to track these trends, because as we're going to discuss for the next hour, companies in the consumer finance space are now facing, not just one set of rules, but in many cases, 50. And it can be really tricky to navigate that from a compliance standpoint, from an enforcement standpoint. And this is a very interesting space, given what's going on in DC. So to our first topic, kind of taking a survey of where the states are focused and what it looks like. And as I mentioned, a lot of this is stemming from the CFPB and the lack of, or the perceived lack of enforcement initiatives. And back in January, we had the former CFPB, Kathy Kraninger, on one of these webinars. And she mentioned, what was the focus during a Trump administration CFPB? And a lot of it was black and white violations, true fraud, not the perceived extension of UDAP that may have happened on the left for years. And this is a chart. I mean, if you see me on one of these webinars, I think I throw this chart up every single time because I think it's really interesting to look at, enforcement trends. Look, they certainly go up, they go down, but the real dramatic difference in a Trump administration is consumer relief. And, I think nothing coming out of DC is to suggest that that's going to change, that the CFPB is not going to have a focus on large consumer relief in the way that it has over the last 4 years. Sure, there might be some enforcement. It might be bread and butter, but it's not something that the Bureau is going to focus on. And so where does that leave us? That leaves us with 50 potential different plaintiffs across the country. We talk about blue states or red states and different initiatives, and we'll touch on this throughout the presentation, where you do have coalitions. You have, certain state AGs focused on DEI initiatives. You've got others giving the opposite guidance. I mean, this is a really unique position for companies to be in, where there's not a primary federal regulator. And now you really do need to track who your state AG is and what they're focused on. And frankly, what sort of multi-states are joining. So Adrian, I mean, you obviously spent time in the Pennsylvania Attorney General's office, looking at the landscape today. Do you have any advice for companies sort of thinking about, okay, I've never really thought about the state AGs before. What do I need to think about now?
Yeah, thanks, Mike. So I spent 18 months as the first Deputy Attorney General in Pennsylvania. Before that, I had some high-level positions in the governor's office. But getting to why we're here, look, I think now more than anything, where we have the CFPB very formally and officially saying that it is going to draw back in a very specific way from enforcement activities. And I'm sure everyone is generally aware of this April 16th memo from Mark Paoletta, the chief legal officer, where they literally lay out that they are going to, quote, respect federalism and really defer to the AGs. And they're going to make their best efforts not to duplicate what the states are doing. That's even more significant in terms of a drawback than what we saw in the first Trump administration. I mean, we've got a preview of this. Now we're really getting it. And so I think that for companies that have a broad footprint, it's going to be very, very challenging because you literally have to go on a state-by-state basis and really stay focused on what the particular AG in each given state is prioritizing. I think that in Democratic, I'm going to generalize, in states with Democratic AGs, you're going to see them continue to focus on probably what we saw out of the Biden CFPB. They will attempt to continue to carry the flag, wave the flag, and move forward. And I think in some ways, they may even try to pick up CFPB investigations that have been ceased under the new administration. I think that in Republican states, you're going to see that they're going to push the Trump agenda. So, they may be looking at DEI issues by way of example. I mean, we all have seen what the Trump administration is focusing on. And so, you really have a lot to do, especially, again, those who operate in multiple jurisdictions. You're not going to see the same level of consistency that perhaps we saw in the Biden administration.
That probably brings us to something that Joseph and I will touch on later, but to sort of preview, I mean, there's now this patchwork, and it's really difficult to track all of this, what's going to change from a consumer protection standpoint. And frankly, from a personality standpoint, because, the reality is for most state attorney generals, they're elected officials. Some of them have aspirations for higher office. I mean, these become political issues in many ways. They campaign on some of these issues. And so it's certainly an interesting space. It's one of the reasons why I really like doing this, the intersection of sort of law and politic. But it can be really hard for companies to be in the middle of that. So, it's really a changing dynamic. And so just taking a step back, sort of doing a 101, right? Where do state AGs derive their authority? I mean, first and foremost, I think for this audience, it's the consumer protection laws. It's their state consumer protection law, but it's also the federal protection laws, because under Dodd-Frank, state AGs can bring those actions under federal courts. And we've seen them. We've seen them band together and file suit together. And rather than filing 6 individual lawsuits, something that I defended for a really long time, they're now filing together from a coordinating standpoint. I mean, I think, Adrian, about one that was filed in Pennsylvania. And so in many respects, the playbook is changing as the states figure out better ways to work together.
Briefly on multi-states, we're involved in 2 in the financial services sector. I'm not going to get into exactly what it involves, but it's an alternative type of financing arrangement. And, the one that I'm thinking about involves 40 states. And what's interesting is, you're not seeing necessarily the Republican states just abandoning consumer protection. I'm not suggesting that. They are picking and choosing things, but they're continuing on with existing actions. And, that will continue. And, in terms of behind the scenes type stuff, a lot of these multi-states will either form at the very beginning of sort of consumer protection investigations into a particular business activity, or they may develop afterwards, after one state maybe paves the ground and sort of sets a roadmap. And I think that's what Mike may have been referencing, where the one we're involved in now started off in Pennsylvania as Pennsylvania only. It's settled. And then other states said, you know what, I want to look into that particular industry as well. And I think a little bit later on in the presentation, I'll kind of touch on some of the nuts and bolts on how sort of multi-states really get started.
So Hank, kind of bring you in here from a white collar criminal standpoint. I mean, from your perspective, whether it's, state false claims acts or Or, we had the current New Jersey Attorney General on a webinar talking about antitrust statutes. Obviously, data privacy is a really big issue, both for blue and red states. Anything to add on sort of from your world and your perspective, working in state AG cases about kind of the breadth of state AG authority?
Yeah, thanks, Mike. Yeah, I think a couple things. One is, it's hard to avoid the headlines of all of the changes and terminations that have happened at the federal level, whether it's Department of Justice, U.S. Attorney, a variety of federal agencies, FBI. So I think you're going to see greater resources devoted to state AG actions because a lot of these people who are leaving those jobs will end up at state AG offices. I can name a bunch right now of people I know who have made that switch or are in the process of making that switch. So I think you're going to see, assuming the budgets of those offices can support it, I think you're going to see a greater presence and greater force potentially within state AGs. And so that's kind of number one. Number two is, the elasticity of consumer protection laws is significant. If you look at Pennsylvania's, for example, just the definition section of unfair methods of competition or unfair or deceptive acts or practices, there are 20 examples of it, and it's not an exhaustive list. And other states are similar. And so, the cases I've been involved in with state AGs asserting violations or alleged violations of consumer protection laws, they really have a broad mandate under those laws. And I'll touch briefly on the false claims stuff. There more and more states are passing False Claims Act statutes. They largely track federal, but they also, have devoted resources to it. You've seen a lot of joint investigations. I'm not sure you'll continue to see those. It depends on the nature of the target or the, who's being investigated and where. But you are seeing a real uptick. And just to kind of go back to my original point, I think across the board, not just because there's a breach, but also because there's just going to be greater personnel experience, whether it's a former investigator for a federal agency, a former lawyer for a federal agency. You're going to see that type of experience raise its head within state AG's offices.
Thanks, Hank. So one of the things we put together as a group is, where do we see the states sort of putting these resources? What are their initiatives? And in many respects, it is, for lack of a better word, a copycat or drawing from the CFPB playbook. And so, we do believe that states are going to focus on digital payment platforms, fintech regulation. We'll get into that a little bit more later in the presentation. Bread and butter, debt collection, servicing practices. This is something that, the states know really well, that they sort of, know how to issue spot. Obviously, with AI and algorithmic decision making, this is something, in my home state, Colorado, they're really focused on and spending a lot of resources thinking about, building sandboxes, maybe not a 2025 issue, but certainly a 2026. And then I think nationwide, data privacy, cybersecurity, you saw California looking into, data tracking. Obviously, Texas has spent a lot of resources building out their data privacy team at the state attorney general level. Jenny's going to certainly touch on overdraft and junk fees. This is, for lack of a better word, copycat, taking up the torch from the CFPB. And then, one that I think we might see a renewed interest in is ESG practices. I mean, this is something that really was hot during the first Trump administration. It would not surprise if this is something that, some of the more Republican AGs pick up again. Access to banking and credit. We've seen, sort of both red and blue talk about, okay, are you excluding certain industries from banking? And so something that, might be a focus in the coming year. And then obviously crypto and digital assets is going to be a focus, especially with the SEC pulling back. Finally, mortgage servicing foreclosures. Again, kind of like debt collection and servicing, an area where the states are very familiar, kind of have the issue spots in their own playbook for how to approach those issues. All right, and now I'll hand it over to Jenny and Adrian.
We put together a list of warning signs that our clients have found have typically predated perhaps a CID or any other subpoena from an attorney general. And things that we advise people to look at, are there any patterns or upticks in BBB complaints that you're getting, in AG complaints, and even in CFPB complaints? I'm not sure if everybody knows this, but all attorneys, whether they're state or federal in government, they have access to review BBB complaints, to review CFPB complaints, to review AG complaints. So they are constantly looking at that for areas. Are there any patterns or upticks in private litigation? Is there something that the plaintiff's bar has seen that has potentially arisen under some of these consumer protection laws that the state AGs can bring? I know Adrian and I saw a pretty substantial AG action that ended up being a multi-state AG action that was triggered by a publication. We also recommend looking at the social media postings of AGs. You'll be surprised to see the types of tweets that they put out there, the things that they put on their LinkedIn profiles. And then in addition, going to these CLEs and listening to these podcasts and conferences, we often hear AGs either previewing an area of focus that they're going into or quite frankly, selling an area of focus to the other people on the panel. We've also counseled folks to look at proposed legislation, as we know a lot of AGs like to try to legislate through enforcement. So certainly looking at what our legislatures are interested in. Adrian, did you have anything to add in warning signs?
Yeah, I'll just, from an insider's perspective in the office, the state AGs are typically sitting in an office building. Actually, in a lot of states, they're still allowing people to work from home. And they're going to be in the state capitol. Maybe they have some branch offices in other major areas in a particular state. But they don't just magically come up with ideas. They're looking for pointers. They're looking for information. A lot of it comes from newspapers, investigative reporters who are saying, hey, all these people are over here getting ripped off. The other thing I really just want to stress is, when you get a Better Business Bureau complaint or you get a letter from a state AG saying, hey, we have a consumer complaint, we'd like to help you mediate it, you need to really pay attention to this stuff. These are all pointers. You cannot take this stuff lightly. If you do, you will almost certainly get bit because you must manage it. And another practical issue that I just wanted to raise is if you are in particular regulated industries, you do need to have a robust compliance function. And your compliance teams need to be very much involved in this, and they need to get involved from the get-go. And they need to help you coordinate and control what's going on when you have these complaints. And that may point you in a direction of, do I need to do an internal review of how we're doing business in a particular area? What am I doing? How do I fix it? How do I make sure this doesn't snowball, and get bigger and bigger rolling down the mountain? The last thing I want to say is, and I've seen this with two clients who got involved in a lot of AG scrutiny. And this sometimes happens, or maybe it mostly happens with startups, but it could happen with very established companies that are getting into a new business area. A lot of times, your focus is just so much driven by market share. How do I acquire market share? And I'm paying so much attention to that. And I don't pay attention to the compliance side because for all the reasons, market share is how we generate revenue. But if you don't allow your compliance function to grow and to be part of this side by side, sure, you may have a lot of short-term gain and be very happy about it, and your executives are happy about it. Your operations people are happy about it. If you're publicly traded, your shareholders are happy about it. But they're not going to be happy when the regulators catch up and start calling you onto the carpet because you didn't pay attention to the regulatory side, and then maybe you violated a state statute or a federal statute with respect to the business that you're in.
And on that point, you really want to make sure that your compliance department is regularly speaking and reporting to those who operate the business. Oftentimes, there are warning signs there, and unfortunately, it either does not get escalated appropriately or it gets lost in transmission. In terms of areas that we think that the state AGs are going to target in financial services, and I know Mike briefly discussed this in the opening, and it certainly was in the CFPB's roadmap, and we are seeing this in both private litigation and AG litigation, and that's junk fees. And what are junk fees? At least in the Biden administration, they were really looking at fees that had to do with staying at a hotel, resort fees. Now we're seeing junk fees all across the industry, and common notion that we are seeing are, were these fees disclosed? If they were disclosed, were they clearly and conspicuously disclosed? Were they hidden? Were they misleading? Was it an auto renewal? For instance, just on Monday, the FTC sued Uber, and one of the claims is based on their allegation that in order for a consumer to end an Uber subscription, they have to, quote unquote, navigate a maze to be able to do that. So those are things that we, and I'm sure Joseph may talk about this a little bit as well, counseling people to look at in their compliance when they're putting out a new product. Of note, there are at least 2 states that have made headway in proposing and actually enacting state junk fee legislation. The first one, California, the honest pricing law or the hidden fee statute, that was actually promulgated and promoted directly by the California AG. So we know that they are looking into these issues. And then Massachusetts, the AG actually released their own fee regulations that are going to be enforceable by the AG beginning on September 2nd of 2025. The Massachusetts AG does list out certain areas, and a lot of those areas have to do with the bullet points that we list there below junk fees. So those are areas that we definitely encourage people to be thinking about as they are reviewing their current policies and programs, and also creating new ones. And then kind of moving on, and we've certainly touched on this and we'll continue to touch on this throughout today's presentation, but the unfinished CFPB business. So lawsuits that were recently dismissed, lawsuits that have been stayed, or stayed investigations by the CFPB. The states are gonna pick them up, and we are seeing this, and we certainly are encouraging clients to look at those cases that were filed by the CFPB last year, and decide whether there are lessons learned that you can look at from a compliance standpoint. Adrian, I don't know if you have anything to add with respect to the CFPB unfinished business.
I mean, look, I think on this point, and I can come up with a couple of different examples. Certain states have always historically been very, oriented towards using the power of state law and consumer protection very aggressively. And they, you could say, were in alignment in terms of theory and practice with the CFPB and the Biden administration. Some of the states are California, Illinois, New York, Maryland, state of Washington, state of Oregon, Massachusetts, just by way of some examples. I have no doubt that before the incoming Trump administration, that there has been lots of information sharing between the CFPB and state AG offices. Do I have firm proof? No. It's from experience and watching how on some joint investigations between state and federal agencies, how they've acted. And to Hank's point, you have almost certainly seen some of those people leave federal government employment and go into state AG offices. Happens all the time. People are invested in these cases. And if they can take a case with them and have a state AG adopt it, they will do so. They're proud of their work. They like what they're doing. They think they're helping consumers, disadvantaged people, things of that nature. And they want to continue this work. So I think you really have to be on the lookout that if maybe you've had a nice positive development because a matter's been all of a sudden dialed back or maybe even terminated by the CFPB, don't be surprised if you see it reappear through a state AG. I think that is very, very possible, if not outright likely.
Thanks, Jenny. Thanks, Hank. All right, Joseph, talking about preventative measures, compliance with state laws. So we're back to the patchwork.
Yes, and I like to start with this slide again, not just because I originally saw it when I got a text from Mike Kilgarriff at 4 a.m. one day saying, hey, look what I did this morning, again, at 4 a.m. But I think it really is illustrative of where we're going with respect to a number of laws that consumer finance entities need to be looking at. And we're going to talk about things that apply to national banks, to state banks, and to non-banks. There's a lot going on, and states are very active in trying to regulate all of these products. Adrian talked a little bit about how in some blue states we might be going back to how things were looked at under the Biden administration. In some sense, the federal government was following what some states were doing with some of the different regulations that they were promulgating. When you look at reporting medical debt, Colorado already had a statute on the books. California just enacted one this year. EWA laws, that was something that a number of states already have those laws. So we're seeing those things, but being aware of those state laws is more important now than ever before, I'd say. I'd say there's kind of three categories that we're going to look at. Licensing, substantive laws, whether they're disclosure, how you're setting up your programs, if you're integrating with a fintech entity, and then the UDAP laws that Hank was talking about, how there was an example of Pennsylvania having 20 different examples of what an unfair practice is. New York has recently introduced a new UDAP statute as well. And a number of parts in the discussion are talking about different practices that might be considered unfair. There's a big focus on consumers being able to get to the right person on the phone. That if one entity is referring them to another entity and they're going back and forth, that can be a level of unfairness. So, looking at what those things are, and we had helped a lot of entities with really reviewing what federal regulators were looking at from a UDAP perspective, maintaining that database of here are all of the different consent orders, or whether it's a circular or different things from the CFPB, the FTC, or others on what they were declaring was unfair, deceptive, and abusive. Monitoring this on the state level is going to be important as well. When I used to say UDAP, when I was talking on the state, you'd hear that there was only one A in that. We are seeing the adoption of that abusive standard there as well. I want to mention just a little bit, one thing that continually comes up is with respect to true lender legislation. And we're seeing this continue to be the case. And that's looking at whether it's a state or a national bank chartering or partnering with a fintech, and the state saying, we think that's actually the fintech or that third party that's making those laws, and therefore they should be subject to the laws of our state. There's also another piece that's going on here, and that is with respect to states attempting to opt out of DIDMICA. There's a case, Colorado has attempted to opt out of DIDMICA and say that its usury rates apply to loans that are made by state-chartered banks to Colorado residents. That's at the 10th Circuit right now. But we're continually seeing ways where states have traditional powers that everybody's been talking about in terms of enforcing consumer protection laws, but they're trying to get more and more active with regulating usury, all of these other types of things as well. Virginia just had passed a bill that was vetoed by the governor that would have brought in, if an entity advertised a loan, it couldn't be above 12%, or serviced a loan, it couldn't be above 12%. So, have some of these backdoor ways of getting at, what interest rate is being charged on credit products. And I'm going to touch on national banks a little bit here. I was talking about the non-banks. National banks have traditionally said, hey, there's a lot of state laws that are out there, but we're a national bank. Those are preempted. Last year, there was a Supreme Court case, Cantero. And in that, the Supreme Court said that the preemption analysis for national banks is a lot more nuanced than perhaps the way that the OCC was thinking about things, and perhaps the way that a lot of national banks were thinking about those state laws. We saw this when Dodd-Frank was enacted, that there was a discussion about what preemption was going to look like after Dodd-Frank. There were a number of Democratic senators and other folks in Congress who were saying that the way that the OCC was putting forth preemption rules was not aligned with Dodd-Frank. We'll see how these things turn out, but we've been assisting a lot more national banks with reviewing what are those potential state laws that purport to apply to the products that we're offering. I think we're going to see a lot more of that. And one example of this is there was a recent Wisconsin appeals court case that looked at a debt collection. It's the Wisconsin Consumer Act statute, and it has a notice and cure provision before you can do certain activities in collections. I think Mike and others had mentioned that collections and servicing is going to be a focus for states, and it's something that easily comes up, whether the creditor is pursuing the individual in litigation or whether the state is evaluating those practices as well. And state banks by and large follow these provisions, non-banks do. National banks have taken the view that some of these laws are preempted. Here we're seeing, this is one of the first cases after Cantero, doing the analysis of a state law with that Cantero lens and saying, no, this state law does apply. So, I joke that there's two ways to really know the state laws that are applicable to the products. Number one is to really to do a comprehensive survey and have the laws and the analysis for, hey, these are the laws that we think apply, that we're going to follow. These laws do not apply for these reasons. And later in the webinar, we're going to get into an example of that we maintain for a number of different clients. Or there's the approach of seeing what states say on a state-by-state basis apply to you. And that I'm a little bit biased in terms of the way to identify state laws, but either way works. Mike, anything you'd add on this patchwork that we're talking about state laws?
Funny, I was actually going to ask you, and I know we're going to get into this later, but from where you sit, you track this, you live and breathe this. I mean, how are companies supposed to track all this and think about, okay, now we've got to re-look at our compliance programs for state laws, or we no longer have the CFPB blog to look at and think through, where consumer protection laws going. I mean, what do companies do?
Yeah, it's a great question. And so I think first and foremost, having that baseline of what are the state laws that states would argue, or just based on plain reading, apply to your product. Looking at what states you're in. If you're in 3 states, looking at those specific laws. If you're in 50 states, having the 50-state survey of those laws. So once you have that, states are becoming more active in enforcing their laws. States are promulgating a lot of laws, but there are different topics that they apply to. And so, when those are coming out, whether or not it applies to your products, you can decide whether to update those terms. Medical debt reporting was a hot topic. Unless you are a consumer reporting agency or in the medical debt business, those are not going to apply to you. Earned wage access laws, similar thing. Now, debt collection is one that continues to become more and more active. New York has introduced a new bill that would provide a private right of action for a failure to follow their debt collection laws. That's one where you're aware of that. Is it changing how you do your compliance? It may or it may not be, but it's really working with somebody who's looking at these for a number of similarly situated entities. So, I mean, you're absolutely right. Like there's a lot going on. It is difficult to track, but it's more important now than ever because we are seeing that state AGs and others are really focused on these activities.
Thanks so much. I'm going to hand it over to Adrian and Hank, who we're going to, again, sort of get back to practical nuts and bolts suggestions for responding when, you're facing an active investigation.
Yeah, I think the first thing is, how did you learn of the investigation? Companies can become aware of investigations through a variety of means. There's a civil investigation demand, could be a subpoena, could be a search warrant, could be a visit from law enforcement agents. So, how did you first hear about it? And obviously, if it's a search warrant, that's a whole separate webinar on sort of how to handle that. The bottom line there is, don't get in their way. But if they want to talk to employees at the site, employees have a right to have counsel. It's typically better to arrange interviews thereafter and not have it done on site. But a lot of times, investigators will not only try to seize documents, but also take people in rooms and interview them. And they have the absolute right to decline those interviews and set them up for a later date, if at all. But again, the first thing is sort of, how did you hear about this? Some practical steps are, you need to initiate a hold on emails and documents. A subpoena, CID, or search warrant will give you some indication of what the AG's office and other investigators are looking at, and that will help guide you in your hold on particular email accounts and documents. The next is to gather as much information as you can on sort of who's looking at this. What unit of the AG's office, who in the AG's office, maybe research other matters that particular assistant AG has been investigating in the past. But knowing sort of who's on the other side of it as early as you can is key. Information is gold at any investigation, and knowing who's looking at it, why they're looking at it, what they're looking at, those are all key. Adrian, you want to chime in on those points?
Well, the one thing I want to sort of inject into this is something that we often think about under Pennsylvania law, but I think in any state you have to sort of pay attention to. And this may seem counterintuitive. Sometimes you'll get, what a civil investigative demand, or they'll sort of downplay it and say it's an access letter, and they want to sort of get your guard down and have you not sort of think this is serious. Whenever you get anything like this, it's serious, and you have to think long and hard about it. There's a nuance in Pennsylvania law, and again, this is why you have to be aware of this in every state, where you also have to think about things from the perspective of every state has a version of the Freedom of Information Act. In Pennsylvania, it's called the Right to Know law. In Pennsylvania, what's interesting is that if you get an access letter, a CID, that is not protected at all from disclosure under Pennsylvania's version of FOIA. Whereas if you say, you know what, I would like you to convert this to a subpoena, which again, a lot of companies will say, whoa, subpoena, much more serious. I don't want to respond to a subpoena. I don't want to ask for a subpoena. I would always tell you to ask for a subpoena, because under Pennsylvania law, if it's investigatory material, it's considered to be that when it's responded to under subpoena, it's protected from the Pennsylvania Right to Know law. So you got to be aware of that. And there's another reason, again, a quirk in Pennsylvania law, where we've been able to make an argument that if information's produced pursuant to a subpoena, not only is it prohibited from disclosure under Right to Know request, which could come from your competitors, from the media, from consumers, from class action lawyers, but we've made the argument, not that necessarily the AG's office totally agreed with us, but it certainly made them pause and think, that it also prevents them from sharing information with other law enforcement agencies. So, in a multi-state, down to the CFPB. So it's a practical issue that you need to really be familiar with every particular state and how they protect information that you're going to produce. You need to think long and hard about that.
Yeah, and just to briefly follow up on that, I'll sort of flip that right to know issue and take it from being a shield to a sword. When I talked about knowledge is king in all of these kinds of investigations, especially early on. What we've been doing a lot in the last few years is, if there is a state AG investigation, we do a right to know request on the agency that might be involved, whether it's Department of Insurance, Department of Banking, whatever the case, Department of Securities. And a lot of states have exemptions for law enforcement activity, like Adrian just mentioned. Some states do not. Some states specifically allow a questioner or someone who's propounded a right to know request to seek all communications between agency X and a particular company or industry that might be adverse to your client. So keep in mind, again, what Adrian said is absolutely true. Use the right to know request to your benefit, but also as an information gathering tool. Right to know mechanisms around the country can really be helpful. The next sort of practical thing, and I alluded this before, is after you identify who the assistant AG is, reach out to that person, get a better understanding of what they're looking at. If it's a criminal case, are there targets or subjects? If it's a civil case, are they looking at the company? Are they looking at individuals, principals of the company? Once you get a better handle on that, we talked about email, freezing emails, hold notices. Who are your document custodians? I mean, really getting into the sort of nuts and bolts of early stages of an investigation, but whose emails should we look at? And sometimes you do interviews to determine which people within the company have really touched this issue in a meaningful way that the AG is looking at. And those people are the ones that you really should search their emails. And then the next and I'm sure everybody on this is familiar with these steps, email reviews, use search terms. Is there any need to review for privilege? You should have a privilege log. And then if you're responding to a subpoena or a CID, begin production. You can often do that in waves, have a rolling production. Again, coordinating and having a consistent dialogue or open communication with the AG's office or investigators is critical to sort of take the heat off of having to produce a whole lot of documents in a short period of time. They're usually reasonable about sort of rolling those things out there. Adrian, any follow-up on that?
Yeah, just one last thing. You have to, it goes without saying, you have to have your antenna up and you have to be really skeptical. And again, sometimes as an investigative technique, they want to downplay things. They want you to think this is not that big of a deal. Just help us, get us the information we're looking for. We'll be on our way. Famous last words. In this 40-state, multi-state that we're involved in that started in Pennsylvania, when that started, and before we were involved, if my memory serves me correctly, it was supposed to be at a very small, discrete part of the authorizing legislation on this particular business activity. And I think the thought was, okay, so maybe we botched this. We'll have to do a couple refunds. This will be easy. I think what happened was, now that was the beginning. That was the tip of the spear into now it's become a 7-year odyssey of investigations. And quite frankly, what it spun into in Pennsylvania was, as Jenny and I have been known to describe things at times, where the AG's office decided, we really don't like this business activity, even though it is authorized under state law. So we're going to engage in what I affectionately like to call legislation through enforcement. So we don't like that the legislature authorized this business. So now we're going to open up a giant investigation, and we're going to nitpick every single piece of the law, and we're going to try to make it very hard to do business in our state. That happens. And my point is, that particular investigation started off with sort of them trying to say, this is nothing, this is a small thing, and then it just sort of, mushroomed from there. So you really need to be skeptical, keep your eyes and ears open, and try to connect the dots about what they're looking at, what they're up to.
All right. So, Mike, I think you and I have this next topic. Is that right?
I think that's right, Hank. Yep.
All right. So this is coordinating with if there's a parallel federal investigation. Mike, you want to kick that off?
Yeah, I'm happy to. I think this is an interesting one given the landscape, right? I think all of us on the call are used to working, side by side with the state AGs, with the federal regulators, and having those strategic discussions with our client of, okay, is it better to keep them separate, or do we want to focus on global resolution? And look, I don't quite know what the landscape's going to look like in the next 4 years, but I think it's something that, when we talk about state AG investigations, it's something to consider, right? It's, how to approach these two entities that may be focused on the same issues, but have different priorities, different directives. And I think the slide, I actually really like the way this slide has laid all this out. Look, who was first in the door? Is there a deference issue? Who would be better for your client to take the lead? Is that where you want to kind of funnel the information and really build that relationship? How can you influence this process, right? I've been on 50-state investigation where there was the CFPB. How to bring those people to the same table when, maybe they're working together, but really they're not. What happens when one walks away? And so it's a really interesting dynamic, and one that should be at the forefront of your discussions in any kind of, large government investigation. Hank, I don't know what you think.
Yeah, just I agree with all of that. And just real quick, I think if you can influence it at all, look at the statutes that the federal people would be looking at to enforce, and look at the state statutes. Where do you think you might have a better shot, either early on through motion practice or later if it goes beyond that to, some decision maker, whether it's a judge or a jury or whatever. And also think about where you are. Are you better off, with a federal investigation that could end up in federal court at a certain area, or are you better off with a state investigation that can end up in a state court in a particular, part of a state? So, those are practical considerations, but they really should guide you early on. I think Michael is absolutely right that in this climate, I'm not sure we'll see as many of those parallel investigations. I think and I know that's not this group, but I think in areas like healthcare fraud and things like that, you'll see, state and federal joint task forces. I'm not so sure you'll see them, when it comes to consumer finance issues, perhaps. But, if you do, I think these are important points to consider.
Before we jump off, we do have a question that Hank, I think your expertise would be helpful, and I'll make one quick comment. Do we expect that states will take up other things that the Trump administration seems to be saying it may not pursue? And in this case, we're talking about money laundering, securities compliance, things of that nature. And my initial observation on that is, I think it depends on the state. And I think it depends on the sophistication of the state in terms of both its laws and in terms of the resources in these other agencies. So, for example, New York obviously has a very robust, financial regulator. And I would say if it's New York, yes. On securities compliance, I think, again, state by state basis, if I look at Pennsylvania, I don't necessarily think of Pennsylvania as having the strongest sort of securities oversight, just, in terms of resources that it's sort of put into that area. So I think that this type of, these types of activities will certainly be looked at the states, but I think there'll be certain states where the chances are more likely and higher than others. Hank?
Yeah, no, I agree with that. I think when it comes to AML compliance and securities, I think it's state dependent. Do the states have statutes that address those issues, and do they have the horsepower within the offices to investigate and prosecute those matters? I think the question also referenced FCPA cases. I don't see any states getting involved in FCPA enforcement. I've done a lot of that over the years. I'm not doing a lot of it right now. I think jurisdictionally, the state would have a problem doing that. Resources, evidence gathering, I don't see any state equivalent to be able to pursue any type of foreign corruption. But, states all have corruption statutes, and if it's centered within the state, and I've done a bunch of them in different states, you'll continue to see corruption cases brought in states that have corruption statutes, and I think all of them do. So, next topic.
Yeah, Adrian, Jenny, I think touch briefly on maybe some strategic settlement discussions, and then we'll close with Joseph.
Sure. So I think what we should all remember is that we should start from a place of settlement as possible, and settlement is what the state's bread and butter are. They don't want to litigate these cases. They don't really have the resources to litigate these cases. There's a lot of turnover, and I think we're going to expect a lot of turnover going forward. So knowing that, I think when you get a term sheet, that's typically what you'll see first in a proposal from an AG. You're probably going to see the kitchen sink. I want all of these changes. I want this exorbitant amount of money, and I want you to do this thing that's not going to make you be able to operate your business in this state or these states. I think that's typical, and I think from our experience on the phone here, we could say that if a settlement wants to get done, a settlement can get done. In terms of, and I think, Adrian, we see this a lot and would appreciate your comments on this. In terms of who should be at the settlement discussion table, A, do you think clients should be there? And B, what do you think about suggestions that you should go above the AGs that are directly involved in your case?
Look, I think we've all seen there are a couple different approaches with state AGs that are practiced regularly. And there are, some companies that spend a lot of time at the National Association of Attorneys General meetings, at the Democratic and Republican coordinates, and they're working on developing relationships with the AGs themselves, maybe some of their senior people. And I think those relationships are helpful. I think they're helpful in terms of developing, intel on where states are going with their investigations and enforcement activity. It's certainly nice to try to lay some groundwork about whether your company is a responsible actor, a participant in business, growing your reputation. That's all very helpful. That said, in my experience, once an investigation gets opened and it's active and it's going within the agency, you're going to create a very awkward and difficult situation if you try to go over the head of, a line attorney general or even, the Consumer Protection Bureau head. The AGs have to support and back their team and their staff, and they have to let the process play out. And if you think it's as simple as, going over somebody's head, I think you're really risking damaging, sort of your ability to successfully navigate in settlement or otherwise. So I would really shy away from that.
Okay, that's exactly what I was asking. So I'm glad that you could anticipate my question. We could obviously talk about this for another hour, but in order to take us home, I'm going to turn to Joseph, who can talk about long-term prevention.
So I just have a slide here on building a state law compliance program. We've talked about that database before, to make sure that you have all those state laws. Then, and I know Adrian and others spoke about reviewing your products against those state laws. If you're introducing a new practice, you're reviewing that against what those potentially UDAP considerations are and others. And I know Mike talks a lot about complaint monitoring, making sure that that's an element of the program too. I just wanted to end with, Mike was asking earlier, how do you track all these different laws? This is an example of how we do some things. You can do this at the state level or by specific type of law. This is with respect to disclosure laws and just kind of like documenting all of these, what the implications are, and then kind of whether you're complying with it by complying with an analogous federal law or whether it doesn't apply to you. So, there's a bunch of different things that kind of go off of this. You have your products and identify which products these apply to so that you can then have, pull up for this credit card or for this deposit product, here are the state laws that apply. So, that question that Mike was getting at, how do you organize it? This is just one example of how we do this for clients regularly. But again, we've gone over a little bit. So in the interest of time, I am going to end it there and I'll turn it back over to Mike.
Thanks, Joseph. Obviously, we have a lot more to say on this topic. And so please reach out. We're happy to come up with other topics, whether it's industry specific, sort of state specific, initiatives. We're always looking for ideas and want to be responsive to our clients. So thank you so much for listening. And we hope to hear from you soon.
To make sure you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, Apple Podcasts, YouTube, Spotify, or wherever you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights about the consumer finance industry. And if you have any questions or suggestions for the show, please email us at podcast, that's singular, at ballardspar.com. Stay tuned each Thursday for a new episode of our show. Thank you for listening and have a good day.